Now we move to the different kinds of defective contracts. As an introduction to defective contracts, there are four kinds of defective contracts: rescissible contracts, voidable contracts, unenforceable contracts, and void or inexistent contracts. The first class, rescissible contracts, are valid because all the essential requisites of a contract exist, but by reason of economic injury or damage to one of the parties or to third persons such as creditors, the contract may be rescinded. So later, di-define natin ano ibig sabihin ng rescinded. Second class is voidable contracts. They are also valid until annulled unless there has been a ratification. In a voidable contract, the defect is caused by vice of consent. The third class, unenforceable contracts, cannot be sued upon or enforced unless they are ratified. As regards the degree of defectiveness, voidable contracts are farther away from absolute nullity than unenforceable contracts. In other words, an unenforceable contract occupies an intermediate ground between a voidable and a void contract. Lastly, ito yung mga tinatawag nating void or inexistent contracts. Kung ako tatanungin nyo, class, it cannot be considered a defective contract because kaya nga void na eh. Hindi na siya makukure. Kasi ang defect, pwedeng ibig sabihin, pwedeng makure. Anyway, for the sake of this discussion, we will include void contract. They are absolutely null and void. Void contracts have no effect at all or cannot be ratified. Now, we focus first dun sa defective contracts na rescissible contracts. Ano ba ibig sabihin when you speak of rescissible contracts? Rescissible contracts are those validly agreed upon because all the essential elements exist and therefore legally effective. But in cases established by law, the remedy of rescission is granted in the interest of equity. Tandaan nyo, class, ha? Valid yung contract dito. Kaya lang, merong issue. Okay? Merong economic injury or damage to one of the parties. So, ang reason behind rescissible contract is the interest of equity. Okay? They are valid. The binding force of rescissible contract, since they are valid and enforceable, although subject to rescission by the court, when there is economic damage or prejudice to one of the parties or to a third person, wala itong defects. So, ibig sabihin, ito ay binding. Okay? However, pag in-enforce ito, magke-create ng injustice. So, ano ba talagang ibig sabihin ng rescission? Rescission is a remedy granted by law to the contracting parties and sometimes even to the third persons in order to secure reparation of damages or repair be caused by them by a valid contract by means of restoration of things to their condition in which they were prior to the celebration of the said contract. Okay? Ano bang requisites? The contracts must be validly agreed upon. There must be, ito na yon, lesion or damage or pecuniary prejudice to one of the parties or to a third party. The rescission must be based upon a case specially provided by law. Yan yung i-discuss natin. There must be no other legal remedy to obtain reparation for the damage. The party asking for rescission must be able to return what he is obliged to restore by reason of the contract. Number 6, the object of the contract must not be legally in the possession of a third person who did not act in bad faith. The period for filing the act of rescission or the action for rescission must not have been prescribed. So right now, hindi ko na muna i-discuss yung number 7 is as a requisite kasi that is for lawyers class. Okay, yung requisite natin, class, dapat pag sinasabi natin requisite, dapat ito present lahat bago pagbigyan na merong rescission. Pero ano ba yung mga pwede mo lang i-rescind? Ano ba yung mga rescissible contracts? Okay? Ang mga rescissible contracts ay specifically mentioned in Article 1381 of the New Civil Code. Number 1, those which are entered into by guardians whenever the wards whom they represent suffer lesion or damage by more than one-fourth of the value of the things which are the object thereof. Okay? Ito yung mga guardians. Nare-represent nila yung mga wards nila na nag-suffer ng one-fourth. More than one-fourth. So kung halimbawa, si G, guardian of M minor, binenta ni guardian yung property ni M worth 20,000 for only 15,000. Okay? Question, is it rescissible? The contract of sale cannot be rescinded because the damage is not more than one-fourth. However, if the property is sold for less than 15,000, pwede mo na siyang i-rescind. Okay? Ano ba ang one-fourth ng 20,000? Ha? 5,000. So, pag more than 5,000 ang lugi, then pwede mo siyang i-rescind. Okay? Very clear ang batas doon. Number 2, those agreed upon in representation of absentees if the latter suffer the lesion stated in the preceding number. Again, what is the preceding number? Ano yung damage doon? 1/4 ulit. Suffer damage by more than 1/4. Representation ng mga absentee. Okay? Ano bang ibig sabihin ng absentee? Ang absentee is a person who disappears from his domicile and his whereabouts being unknown. Ito yung mga hindi makita. Merong mga taong nawawala na lang bigla. So may mga in charge sa kanyang mga property na nag-a-administer. Ngayon, ang sinasabi ng batas, kung yung absentee ay magsasuffer ng more than one-fourth ng damages, then pwede siyang magpunta sa korte at sabihin niyang i-rescind yung kontrata, yung nabenta or kung ano man ang ginawa dun sa property. Just like dun sa number 1 natin ng mga contracts that are rescissible. Okay? So what else? Number 3, those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due. Okay? Ulitin ko ha, those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. Okay? May mga requisites yan, class. Yung number 3 na yan, para mas maintindihan nyo. Una, there must be an existing credit prior to the contract. Dapat merong existing credit. And, although it's not yet due or demandable, basta na mahalaga, merong nag-exist na credit. Okay? Number 2 na requisite nun, there must be fraud on the part of the debtor which may be presumed or proved. Ulitin ko, class, ha? Dapat may fraud dun sa nangungutang or sa may utang na pwedeng ma-prove or ina-assume lang natin or may presumption. And number 3, as a requisite, the creditor cannot recover his credit in any other manner, it not being required that the debtor be insolvent. Hindi naman kailangan insolvent. Ang sinasabi lang dito, hindi makarecover ang ating creditor kay debtor, where the fraud charge is not the one used to obtain a party's consent to a contract. It cannot be fraud of credit but gives rise to rescission of the offending party. Okay, explain natin maigi yun. Okay. There must be an existing credit. Nangutang, nag-e-exist yung credit. Okay, nangutang si debtor kay creditor. Okay? Hindi pa due. Hindi pa due kasi ang utang ay May 30, katapusan. Lumalabas, class, na si debtor ay may property siya na supposedly mortgage nung bahay. Yun pala, yung property niya ay hindi kanya. Okay? Hindi kanya yung property na minortgage siya na pang-utang niya kay creditor. So now, class, what creditor can do is rescind the contract na ginawa nila prior to the credit. Okay? Or class, if may property si debtor at yung kanyang property ay binenta niya in fraud of his creditor, pwedeng i-rescind yung kontrata na pinasok ni debtor sa pagbenta ng kanyang property. Okay? That is a rescissible contract. Number 4, contracts which refer to things under litigation. If they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. Bigyan ko kayo ng example para mas madaling maintindihan. Si A, dinemanda niya si B for the recovery of a parcel of land. In this case, syempre dahil dinemanda, ang tawag sa property is under litigation. Okay? If during the pendency of the case, binenta ni B yung property kay C without the approval of A or the court, the sale is rescissible. At the instance of A, in case he wins in the suit for the recovery of the land unless C is in legal possession of the land in good faith. A, however, may protect his right by filing a notice of lease pending. So, huwag nyo na masyadong intindihin yung part na yon. Sinishare ko lang sa inyo. Pero yung pinaka-importante rito is that pwedeng i-rescind ang kontrata ng pagbenta ng property ni B kay C nang walang approval ni A or sa court. Kasi yung property pinag-uusapan is already under litigation or pinagtatalunan na. Number 5, all other contracts specially declared by law to be subject to rescission. Okay? So marami pa yon, class, pero we will focus on the 4 rescissible contracts. Paano kung nagbayad? Payment made in the state of insolvency. Ito yung mga bayad. Okay? Payment not exactly of a contract. The debtor is insolvent. If he does not have sufficient property to meet his obligation, then ito yung sinasabi natin na yung debtor hindi kailangan judicially declared, ha? Kasi usually ang insolvent class, dapat yan judicially declared. Ibig sabihin, lumapit ka sa korte, hindi na ako makapagbayad ng mga utang ko. Ako ay wala ng salapi. Wala na akong pera. So, class, judicial insolvency, madalas yan dapat declared. Pero in the case of rescissible contracts, pwede siyang hindi because the payments must have been made for obligation to whose fulfillment the debtor could not be compelled at the time they were effected. Included in the obligation referred to are not only those who have not yet become due and demandable. Okay? So, pwede yan. Okay? Pwede. Now, nature of action. Ano ba yung nature ng rescission class? Pag sinabi nating accessory lang siya or subsidiary, hindi siya yung principal action. Ibig sabihin, merong mga major action bago mo i-rescind yung isang kontrata. Okay? So, rescission is not a principal remedy. It is only a subsidiary, meaning that it cannot be availed of only if the injury party proves that he has no other legal means aside from rescinding the contract to obtain redress for the damage caused. Ibig sabihin, kung meron siyang ibang paraan para mabawi ang kanyang pagkakalugi and damage class, then rescission is not the primary action. Subsidiary lang. Okay? Baka pwedeng maningil na lang siya ng damages at wag niya nang i-rescind ang kontrata. Up to what extent ang ating rescission? The entire contract need not be set aside by rescission if the damage can be repaired or covered by partial rescission, because the rescission shall only be to the extent of the creditor's unsatisfied credit. The policy of the law is to preserve or respect the contract and not to extinguish it. Okay? Example, G, the guardian of M, a minor, was authorized by the court to sell two parcels of land valued kunyari ng 200,000 each. G sold the two parcels to B for only 200,000. In this case, class, the entire contract need not be rescinded. The rescission may properly be applied only to one parcel to cover the damage by G. But if G or B is willing to pay the difference of 200, rescission is precluded. Okay? Rescission creates mutual obligation of mutual restitution. Anong ibig sabihin nun? When the court declares a contract rescinded, the parties must return to each other kasi mutual restitution, return to its original. Number one, the object of the contract with its fruits and the price thereof with legal interest. Okay? Yun yung nakikreate na obligasyon ng rescission. The purpose of rescission is to restore the parties to their original situation. The law presumes that the party who received the object of the contract has enjoyed the fruits thereof, while the other has used the money, which is the price of the object. With respect to the fruits, the rules on possession govern. Okay? So that is rescission class. Now, when we speak of voidable contracts, class, ito yung voidable contract. I-enumerate muna natin the following contracts are voidable or annullable. That's the other word for voidable, annullable. Pwedeng i-annul even though there may have been no damage to the contracting parties. Okay? That is Article 1390 of the New Civil Code. Ano ba yun? Ano ba yung pwedeng i-annul ng mga kontrata? Number one, those where one of the parties is incapable of giving consent to a contract. Okay? Incapable of giving consent to a contract. Number two, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Tandaan nyo yung class, ha? Yung dalawang yan, incapable of giving consent to a contract, or those where consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. I discussed that already. Now, i-apply na lang. These contracts are binding unless they are annulled by proper authority in the court and they are susceptible to ratification. Ratification, may discuss natin. Meaning of voidable contracts are those which possess all the essential requisites of a voidable contract. Kaya nga, valid contract, essential requisites are present, except but one of the parties is incapable of giving the consent, or consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Ano yung binding force ng voidable contracts? They are valid and binding between the parties unless annulled by the proper action in court. Once ratified, they become absolutely valid and can no longer be annulled. So, pwede rin siyang i-ratify. Okay? Para siyang, pag na-ratify mo siya, para siyang valid talagang kontrata. Okay? Pero pag inannul mo, ibig sabihin, hindi mo pinayagan. What are the kinds of voidable contract? A contract is voidable if the defect is caused by either legal incapacity to give consent or one of the parties is incapable of giving consent. Okay, ito yung mga unemancipated, yung below 18 years old, kasama dyan. Okay? Kasama din dyan yung mga Siyempre, we have to, yung mental incapacity. Yun diniscuss natin, yung lucid interval. Violation of consent where the vitiation is done by mistake, violence, intimidation, undue influence, or fraud. Na-discuss na rin natin yan. Okay? Nagbigay ka nga ng kontrata because yun pala may mali, mistake. Yun pala violence, may physical force, intimidation, threat. May threat sa iyong sarili, sa pamilya mo. Undue influence, of course, yung moral ascendancy na tinatawag. And fraud, as we have discussed, it is the causal fraud. Okay? We have already discussed that, yung vices of consent. Ano ba ibig sabihin ng annulment, class? When you say annulment is a remedy provided by law for reason of public interest for the declaration of the inefficacy of a contract based on a defect or vice in the consent of one of the contracting parties in order to restore them to their original position in which they were before the contract was executed. Okay? Ganun ka-importante yon. Kasi ang annulment class, ibig sabihin, hindi ka pumapayag. So, nung nalimpungatan ka na, okay, ikaw ay nagising sa katotohanan. Sabi mo, ay hindi talaga ako pumapayag. Natakot lang ako. Or tinakot lang ako. So, ipapa-annul mo yung kontrata. So, that is allowed. Kaya siya annulment. Pero pag ni-ratify mo, class, ratification means that the one voluntarily adopts some defective or unauthorized act or contract which, without a subsequent approval or consent, would not be binding on him. Okay? Ratification cleanses the contract from all its defect from the moment it was constituted. The contract thus becomes valid. Hence, the action to annul is extinguished. So, yan ang ating ratification. Inadopt niya yung defective or unauthorized act. Tinanggap niya. Kaya nira-ratify niya ang kanyang aksyon. Okay? What are the requisites of ratification? There must be knowledge of the reason which renders the contract voidable. Dapat alam na meron talagang defect. Such reason must have ceased. Tumigil na. Kung tinatakot ka, dapat tumigil na. The injured party must have executed an act which necessarily implies an intention to waive his right. Okay? Dapat meron siyang intention to waive his right kung halimbawang nira-ratify niya na. 'Di ba? Kasi sinasabi niya na hindi. Ready na ako. Hindi naman ako tinatakot na. Tinatanggap ko na. Okay? So that is the requisites of ratification. Okay? So, class, I have discussed 2 defective contracts. So, thank you.